Franklin, you brought up a really interesting article or potential bill to my attention regarding small claims court legislation for copyright issues. Do you want to give us a little bit of background on that?
Yeah, definitely. So in 2013, I believe it was, let me pull up my notes. Yeah, in 2013, there was a report from the Copyright Office regarding the creation of a small claims court. So if you've ever been involved or had to try and protect your works as a copyright owner or creator, then you realize that, first of all, the bar to go after infringement is basically getting into federal court, and that can be very expensive. So if it's something that is not really valuable or there's not much money to be had by the end of it, and especially if you haven't registered the works, in that case, you're really kind of out of luck and you're having to come up with the decision-making power of whether you want to spend money and possibly be out thousands and tens of thousands of dollars or more by pursuing litigation. So there's been this need and a recognition for the need of a small claims court from the Copyright Office. So there is a new bill, or there's new legislation that's been introduced called the CASE Act, and there it is on the screen. So it's pretty interesting to see how this will go about getting created and what the overall implementation of it will be. But I think, in my opinion, it will be a very good option for copyright owners to be able to hopefully have an alternative to federal court for protecting their copyrights.
Could you go, I guess, a little more into the weeds about structurally what this would look like for the average creator that has a small copyright claim? What would they? Why would this be a preferable option than to be filing the traditional claim in court, or in federal court? Sorry.
Well, I mean, I guess money is the main reason. I mean, that's one of the sticking points is just financially it's extremely difficult to fund litigation, not only like its attorney's fees, but court filing fees, all of it. And there's if you just go and look at any docket, like the ones we were just looking at related to copyright filings or copyright litigation, the dockets get drastically numerous in the number of filings that there are. So I think that's one of the main reasons behind this, one of the policy reasons behind creating this.
I'll be honest, I think that this is just showing my ignorance of small claims courts in general. So I'm going to leave this to our panel to maybe explain a little better. Mike, you were saying?
I love this bill, personally. I think it's a great idea. All too often, you've got really legitimate claims of copyright infringement that it's just not practical necessarily to enforce it in federal court. Obviously the federal court system is great, and the judges by and large are very familiar with copyright and experienced in this particular area of law, of course. But it can be very, very expensive, especially if you don't have the likelihood of statutory damages or attorney's fees. And so you're left with really not a viable method for seeking redress. And this, of course, is for very small claims of copyright infringement. I think the most that the Copyright Board could award is up to $30,000 in a single proceeding. So if it's a relatively minor infringement in terms of dollar value, it seems like it's a great place to go. It seems like the process is going to be a bit more expedited. I believe there is discovery under this proposed bill, but no doubt it's not going to be as formalized as in federal court. And this is all voluntary, by the way. We should make it clear that you're not forced to, at least as I read this bill, even if a plaintiff initiates an action before this Copyright Board, I don't believe it's mandatory. I believe that the defendant can still go to federal court to have the case litigated there. But maybe I'm wrong on that. It looked like it was voluntary by the parties. So
no, I agree. That's what I was understanding after reading it as well. This voluntary option. So.
Right. I guess my only experience with the Copyright Office is their sort of triennial rulemaking process. But when I think of the Copyright Office and efficiency, I don't really think that those two words are usually close together in the sentence. Do you think that the copyright, so I'm imagining, for example, small copyright claims are basically the bread and butter of YouTube takedown requests. And if we're seeing, millions of those per month, which I think is what we're seeing, do you think that the Copyright Office would be effectively more or better equipped to handle that backlog than maybe some more, I don't know, a different approach. Is this really going to be effective, do you think?
Well, the legislation itself provides for staffing. I think it sets up a copyright board, and I think there was some reference to that a couple of staff attorneys that will be responsible for administering claims and so on and so forth. So I think it's going to be handled by a separate, a subset of folks at the Copyright Office, I think. Franklin?
Yeah, I'm not positive about that. It's still early on. I haven't read through the entire thing yet. But I wanted to go back to what you mentioned, Emery, about the situation like we're seeing with like YouTube's Content ID system. I think the difference here and why you really shouldn't compare it, at least in my opinion, is because you're looking at an automated system that YouTube does where it's just generating all these it's generating all these claims against content. So what this would be more of is the active decision to go this route by individual copyright owners. So it's not just going to automatically be, as soon as there's an infringement, some algorithm's going to detect it and then automatically send it into the copyright into this process. But I mean, at least now, I say that, and then a couple episodes ago, you had all the people that were doing the bots. So I mean, I say that now, and it could easily be changed. But I would hope that it doesn't go that route, at least now, for the sake of not having it automated. But yeah, I think that's kind of a distinction that I would draw between the two.
Let me just ask a question. I'm not that familiar with the details of the proposed board, but does it enable people to be represented by attorneys, or does it prohibit that? Because I know in what we normally call small claims court, attorneys are not permitted. People have to represent themselves. Did it say anything about that?
I believe it did. I believe it said you can either go it alone or you can have counsel represent you. I believe I saw that in the bill.
Okay. It's interesting. Yeah.
Well, I will defer to Mike's optimism on this issue then. And keep my fingers crossed that this is going to do some good in the world. I think we've got
I may ultimately be wrong, Emery. Maybe it's going to be a complete disaster, but I think I don't know how this legislation was ever proposed. I mean, I know it's been kicking around for a while. It's interesting because you wouldn't think that this would catch the attention of Congress, particularly given what's at issue. It's really small acts of infringement, at least in terms of small dollars. So I don't know what the history of it is, but I think it's an interesting proposal, and I'll be excited to watch it and see if it actually passes.